are staying out of hot water, legal responsibilities for the facility manager. Before we do start, everyone is muted for audio quality. If at any time during the presentation you have a question, certainly please feel free and type it into the chat box and we will answer them at the end of the broadcast. Today our presenter is Kit Tuvison. He is the president of Tuvison Associates, an international facility management consultancy company focusing on FM organizational development, strategic planning, workplace strategies, FM sustainability strategies, and educational training development. In 2002, Kit graduated into consulting from a 36-year Hewlett-Packard career where he managed site facility teams, global program managers, cross-functional teams, and for 10 years served as HP's Global Director of Facility Management Operations and also Global Director of Environmental Health and Safety. Kit is a widely recognized FM professional with an extensive teaching and presentation background. He is an advisor to 3 startup companies focused on products and services critical to the successful facility management professional. He is a certified facility manager, a sustainability facilities professional, was board chairman of the International Facility Management Association in 1998, and is a past president of the FM Consultants Council of IFMA, and is also an IFMA fellow. Kit, welcome and thank you. The floor is yours.
Thank you, Josh. I always appreciate having a chance to share expertise and help connect some of the dots within the FM community. I will apologize that I've been taking voice lessons from Clint Eastwood, and so my voice is a little scratchy this morning, but I'll try to blow through that so we can have a good presentation. A couple of things about presenter introduction that can add to what Joshua just mentioned. First of all, I am not a lawyer, and it's kind of nice when people say that because sometimes people who think they're lawyers act like lawyers, and in fact they're not. But I'm not a lawyer, but I have had a career in the facility management industry, and my experiences have touched upon a number of situations that involved close relationships with both internal and external legal representatives, and so we're certainly going to try to tap into some of those experiences that I've had and share some of that advice and give you some new perspectives possibly on thinking about how do you relate with the legal communities that are involved in you performing your FM job. You know, the FM service is the role that we all play. Largely, this particular webinar will work for both practitioners of the delivery of FM services, as well as to the servicing community who give us the products and services we need to be successful. Sharing knowledge is a big part of how we are, how we grow in our careers, how we are successful in our careers, and having some fun along the way is certainly my belief. It's a tough job being in the facility management world, and so finding a way to at least find the enjoyable moments, capitalize on those, learn from those, and share those is certainly a big deal. So what are we going to talk about today? Well, we'll talk about understanding what are some of the legal risks, what are some of the legal aspects that we have for facility managers, and how do they show up. In some cases they're obvious, in other cases they're not obvious. And so we'll take a look at that. We'll also take a little tour using a metaphor, what I call legal physics, about kind of different ways of thinking about legal problems and how we deal with them, and we'll look at some of the principles that were given to us hundreds of years ago by Sir Isaac Newton. Have a little fun with that. Taking sides. Anytime there's almost every time there's a issue with legal interpretation, that means someone has a perspective, taking a side, either taking a perspective because they think it's right, well, we always do think it's right, or they're told to take a side. And so trying to understand, you know, whose side are you on at any given point in time from the facility manager's perspective is important. I told you so. You've heard that once, you've heard it a million times. You've said it yourself. Who's saying it to who? How important is that in terms of advice given, advice taken, advice not taken? Certainly that's something we need to be paying attention to as we navigate through issues, legal issues in our facility management world. And then lastly, kind of an FM legal game plan, some of the things you might think about doing, areas you might investigate, activities you might launch to tune up and make sure that you've got your FM game plan is in good a shape as it possibly can be. But before we start, anytime you talk about dealing with lawyers and lawyer presentations, you always have to have some sense of just understand how lawyers think. And these are some of which there are millions of lawyer jokes. But the minute you read something you can't understand, you can almost be sure that it was drawn up by a lawyer. And so many of us click that box on the computer saying, I have read the terms and conditions. You know, if the sodium pentothal was injected, there'd be millions and millions of us that say, yeah, I just kind of trust what they're saying in there, which could be good news or bad news depending on if there's ever a problem. Good lawyers know the law. Great lawyers know the judge. In many cases, it's not the lawyers making the decision about what's going to happen with respect to a legal issue. It's going to be an arbitrator of some sort. It could be a mediator, or it could be a judge, could be a jury, could be all kinds of adjudicating individuals or groups. And so a great lawyer knows the judge, not so much personally, doesn't play golf with them per se, but knows how they operate and what their trigger points are, and how information presented to them in one way can be more effective to serve your cause than maybe a different way. And she is no lawyer who cannot take two sides. It's amazing when you see lawyers going what appear to be after each other legally in a courtroom, and then at break time or lunchtime or whatnot, you can see them enjoying each other's company in many cases, or having lunch, and be able to separate out the job part from the legal responsibilities that they have and still be true to their clients. So just a couple of fun things. Legal basics of FM. Some of the basic things, and this is just a small list of the kinds of topics, but these are kind of areas that commonly show up in a facility management professional's lifetime. That's certainly the whole area of contracts. A lot of what we get done is through a contract where we ask somebody or some organization to do something for us. And in many cases, the procurement of goods and services are done via contracts, and those are, in many cases, almost always cases, legally binding documents, legally binding contracts. And so we need to know that they exist. We need to know not necessarily the infinite details, but what is the philosophy in our company about contracting and contract law and enforcement and rigor and staying up to the current speed in terms of best practices. We're all familiar with regulatory requirements of FM. We have many kinds of oversight in our job, people looking over our shoulder, our team's shoulder, and our supplier's shoulder to say, are you doing it right? Are you following the rules? You know, do it this way or else. And so keeping track of those regulations is certainly a big deal. So it's beginning to sniff around the whole, how do you know what the requirements are, which gets into information management and data management. Certainly an aspect of success for being good stewards, good legal stewards as a facility manager. Labor contracts, labor law, both specifically for a project or for just in general getting work done. Every jurisdiction, whether it's state, country, municipality, usually has a whole host of employee type constraints, and you need to be paying attention to those issues. And certainly if there's unions involved with respect to union contracts, there's some more blending of contracts and the actual getting work done through the labor forces. Environmental always has been around, always will be around, tends to get, in my personal opinion, abused a lot about what people think. It tends to be a nasty word, politicized in many cases, and here the case is the word is being used in kind of the small e, it may be environmental, that there are environmental risks and aspects that are either regulatory or make sense, or policies and procedures that we choose to put on ourselves or on our suppliers, and those can have the same basis for a supplier keeping a contract or not if they're not following the basic environmental aspects that we choose to put out there. And last, the whole liability and risk management. Accidents happen, and no one wants them to happen. We try to put forth procedures and training and activities in a way that minimizes that liability and the risk management, but it does happen, and that's why there are insurance companies. There are ways to help both mitigate and prevent, hopefully whenever possible, but when not prevented, ways to deal with the outcomes and the aftermath of some kind of an event that happens. So those are the things that we see from time to time in our careers. I've chosen to kind of put some of these things in perspective in terms of why would I want to do anything, or how do I take action, or how do I think about these various risks. And so I've chosen a framework based on three of Newton's laws. Sir Isaac Newton, in the 17th century philosopher, mathematician, came up with the laws of motion, the three laws of motion, in 1687. So I'm going to show you what the three laws of motion are, and then I'm going to explain those in a different term in terms of the FM law with respect to legal activities. The first law Newton came up is an object will remain in motion unless an external force is applied to change its motion. If it's going in one direction, it's going to keep going in that direction until some external force is applied to change that. And how does that relate to the FM? Well, an FM problem, certainly an FM legal problem, will continue to be a problem unless you do something useful to improve the situation. So hope it goes away is a strategy you sometimes hear. And in many cases, that's the worst that can happen, is hoping the problem will go away, either because you don't understand it, or you think it's a temporary problem and you're not really sure, you haven't done anything, and you do diligence to look and find out, is this going away on its own? And so many FMs inadvertently sometimes think the problem will go away if they just kind of ignore them, and that can be very dangerous. Newton's second law of motion says the larger the mass of an object, the more force it takes to get it moving, kind of like the whole inertia thing. If it's a big problem, it's going to take a lot more force. So that shows up in terms of an FM corollary. Big escalating FM problems need a bigger than usual response to get them moving towards a successful resolution. So this may seem like a familiar problem. It may be a familiar problem, but it may be of a scale and magnitude that prior techniques or resources or contractors or internal teams to deal with those problems may not be adequate. And so it may require resolutions of some of these problems if it's certainly involved in some kind of legal things. It may require unplanned or unbudgeted resources. And so you have to be brave enough and bold enough to say, this is different than before, and we need something different, and be able to scale up and document what those larger than usual response teams or resources are. And in many cases, justification or re-justification is going to be necessary. And not everybody's going to automatically take your word for it. Not everybody's going to assume that just because we say we need more, that it's going to automatically be there. And in many cases, the economic costs are more easily understood. They're more difficult to get. But in fact, sometimes the non-economic cost, the cost of reputation or whatnot, that could be damaged, could be much more significant to your company in many ways in terms of keeping the business alive or keeping the company's reputation strong. Third law of Newton: for every action, there is an equal and opposite reaction. What's the FM equivalent? Well, some people, managers, contractors, regulators, shareholders, etc., may resist your best intentions to fix the problem. The best laid plans of mice and men. And in some cases, you don't even know where that's going to be coming from. And you think you've got a good game plan in place. You've got the resources. You've got the legal help. You've got the outside resources. You're working on fixing some kind of a spill. You're trying to get a piece of equipment back in business. There's been maybe an injury or a personal protective equipment failure of some kind that's causing some difficulties. And in some cases, you look around and you say, "Now, I thought we're all going to kind of have the same perspective here." In many cases, people don't. And so one of my favorite sort of tests for what's going on here when I'm working with people is trying to understand what I call the P's and the E's. The P's are perceptions. What are the perceptions about what's happening here? Do we all see the same thing from the same point of view? Do I see this as an opportunity or a problem? Do I see this as a big deal or a small deal? Do I see this as something that can be easily handled and passed on down through, or can I get someone else to take care of this as kind of a normal task? Or is there something about this that's being perceived as a huge deal and I'm not getting it? And so getting those perceptions lined up is critical, especially if you're going to be talking about legal kinds of issues. And on expectations, same thing. Who's expecting an outcome, and what is that outcome, and how, when those expectations can be different, especially if you're working with things like environmental issues. How clean is clean? Or we have expectations in timing. Well, we'll get this Gulf oil spill thing all cleaned up lickety-split in 2 weeks. And then all the subsequent legal issues that can fan out from that if those expectations aren't understood, met, and agreed to. So we've got 3 laws of Newton that we've been sort of thinking about, that objects will remain in motion, and if it's a big object and you want to get it moving differently, you got to put more force on it, and then watching out for this equal and opposite reaction, in some cases coming from places that you just did not expect that reaction to come from. Here's a framework that I'm going to use for the rest of our morning talk here about how to prepare ourselves in terms of what are some of the discovery aspects, what are some of the planning aspects, how do we make changes, and then appropriately, how do we sustain those changes once we put those in place. So from a discovery standpoint, and not from a legal discovery, but just the whole idea of discovering what's going on, it's a big part of any legal activity. The formal versus informal techniques for getting information. What are the facts? And doing the Q&A work and investigational work. Some of the older folks in the audiences might remember Paul Drake. Who was Paul Drake? Well, he was the investigator that worked for Perry Mason. And Perry would say, "Paul, go out and find out what the policeman's report said about that, or go see if there's any evidence in the bedroom about that, or if there's any knife splatter," kind of the old CSI thing. But there's formal and informal techniques for discovery. In many cases, the facility management function has information sources. The question is, are they organized? Can you get a hold of them? In some cases, if you're looking at things, if you're looking at replacement parts that failed, do you have a chain of custody? Do you know who actually repaired this part? Do you have records and whatnot? So discovery is an important part of managing your legal affairs and being careful about what's formal versus what's informal, especially if you think there's going to be any kind of evidentiary material happening here. Then getting good, solid legal advice early to say, be careful about who has control of this or touching that or whatever. Due diligence is important. Making sure that we get the information that we think we need to have. Due diligence, in my case, we used to do a lot of mergers and acquisitions and changing the space. And Hewlett-Packard and I supported the real estate acquisition disposition manager, and he would ask for, "Gee, we're gonna sell one of these old HP buildings." It was an old process building. Well, what all went on inside that building? Well, we had some chemical processes. Well, we need to get everything that happened in there, Kit, and be able to prove and disprove in case there's any kind of a chemical spill. If there's something that someone says happened on our watch, we can say, no, we got the record saying that we didn't use that hexatrijuncide. That was someone else that took over the building after we did or prior to us, and we've got the data that they were the ones that were spoiling groundwater, whatever it might be. But the due diligence is very important to really get that list made out. And this, again, is where getting advice from lawyers and other resources to make sure we're finding that information out and supporting a team. In the case of a particular event happening, at HP, we used to nickname things a lot with three-letter acronyms, and so the SUG factors. What are the SUG factors of something that seems to be going on right now? How serious is this situation? Is this life-threatening? Is it serious in terms of business? Is it disruption? How serious of an issue is this? Urgency. Is it need to be dealt with now? Is this something that is going to be involved in public awareness of an event or an activity or death in a factory or something like that? How urgently do we need to get our teams pulled together and working on this? And then growth. If this is some kind of a growth problem where it's like the food health, that you've got some problems with the oranges, or we got some problems with the lettuce or whatnot. How fast is this growing in terms of the shipments? Where do these shipments grow? Where they go, and then tracking that stuff down. So, thinking about the SUG factors whenever you're dealing with a particular situation that may have legal ramifications. Facts, opinions, and lies. This kind of ties back into the P's and E's. When you're working with a legal situation, a lot of agendas show up. Not always easy to tell what those agendas are and in whose favor or disfavor are those agendas working. And so separating out facts, opinions, and lies, and being really clear about where did that come from, and doing the fact checking and finding the evidence as much as you can, the direct evidence, not what someone thinks is going on, but can we actually see what happened? Can we actually get the MSDS material data safety sheet on this particular product that was allegedly involved in this accident? And then understanding on the discovery category of taking sides. Who stands to gain from their perspective, who stands to lose from their perspective, and where are you on that? And where is the company, and who's being represented here? In some cases you have clients, you have customers, and they have rights, and you have the corporate stakeholders, and they have rights, and sometimes those rights appear to be in conflict. And here you are, the facility manager, in an incident or a situation where you're trying to say, who am I trying to not promote, but who am I representing? And that's where getting good legal advice is important, and that may be difficult for you in terms of this taking sides, in terms of taking responsibility. I mean, certainly you want to be able to be as fact-based as you possibly can, and saying my job is to be as honorable and as fact-based about what's going on. And I will understand that I may have a view, an FM view, and there may be other people's view about what's going on. There may be an FM view in terms of asset management, asset preservation, procedures that we go through, things we do in part of our routine maintenance or engineering or project management. And there may be other people saying, gee, that's not necessary, you don't have to do that. Why do you do that, Kit? And so that could be leading to a conflict or something that is perceived by the legal team as not helpful to your organization. But you say, well, this is a standard that we're supposed to be applying to, or it's a regulatory issue, and we don't get to choose which part of the regulation we have to adhere to. We adhere to it all, and here's what it is, and we'll try to figure out how that adherence to that regulation has an impact on us as an individual. Who is your client? When you think about it from an FM standpoint, is my client the employees, if there's a health safety issue here? Is it management? Is it the consumer? Is it your teammate? Who is your client? And so, asking yourself that question and getting, again, what you would want to be sure is competent advice that someone is saying. You may have multiple clients, and so you may be acting in different roles as an FM, depending on what the situation is you're coming up against. So something to think about. And then potential conflicts of interest, and those inevitably show up in either large or small ways, and trying to be prepared to say, we're going to talk about something that that I had a personal involvement in, or this is a situation that has a supplier that's a friend of mine, or it's my brother-in-law or whatever, and so I need to step aside and I can't get involved in this particular discussion, or this component of a discussion. So it's a fair question to ask. Are there potential conflicts of interest? And lawyers will ask that question in great detail, so be prepared to answer that. The conflict examples, event reporting. There's a company policy on something that we do or don't do, or we can do at break, or the policy about how we label things here with certain kinds of labeling to make sure. We got a labeling issue here with hot water, cold water, or this is not a drain pipe or a waste pipe, this is something else, and the regulatory requirements require one thing, and we've got a company policy that kind of supplements that, and being very, very clear about what is the reporting requirement, the documentation requirements. There may be contract terms and conditions that you're asking your suppliers to adhere to, and making sure that they understand what those requirements are, and that you report as appropriate. In some cases, you need to get some advice. Get advice. Don't rely on perceptions and expectations to always give you the right answer. Another conflict example might be protecting intellectual property rights. Certainly with a lot of the companies that have really clever, smart people coming up with really smart ideas and products and circuit designs and what have you, trying to be clear about what are the intellectual property rights here, and what is disclosed and not disclosed. And again, in larger companies, those IP rights are very clearly specified and detailed, and so they may have you may be working as a facility management professional in an area that has certain kinds of R&D activities going on, not uncommon, and you have to respect the intellectual property rights. About, well, we're going to document this scene with the camera. Well, let's be careful now, because we don't want a picture of the latest and greatest invention here that can go off onto the onto Twitter, and all of a sudden I've got a secret is no longer a secret. So anyhow, just something to think about. Employee supervisors certainly are conflict examples in terms of basic rights that individuals have as an employee, and supervisors kind of have rights to know, so to speak, and so what are those boundaries? Start and stop, and asking, if it's a personnel matter, asking HR and HR's legal reps sometimes to get involved and say, these are things you can talk about, can't talk about. The employee has a right to express their opinions or ideas or concerns separate from the supervisor. They have, if that's in case the policy, which typically it is, then make sure that that's observed, and that they have a chance to give their side of the story without being hounded by their supervisor. So not so much about you, but it might be someone on your team thinking they have the right to hear everything that their employee says about that particular accident or whatever it might be. Developing successful plans to help mitigate and to be better prepared as a successful legal support team member in the facility management function. The first thing is think about, in terms of your taking a clean slate out, or when a legal situation arises, is what is the current status? What is happening now? Not what do people think is happening, but what can you document? What can you actually put down and say, this is what's really happening? And being able to, at that point, reference what should be happening, because you're going to be beginning to look for deltas and see what the differences are from what should be happening. But what is the current status, and what does success look like in terms of trying to say, if we can mitigate this problem, what does mitigation look like? What does it feel like, and who's involved, and is it a financial measure? Is it a procedural measure? Is it a judgment by an adjudicator of some kind, saying success looks like we've been deemed to not be responsible for this, and at the same time we're not being deemed responsible, we think there's some better practices we can put in place to even more improve on the situation, so it's even much less likely to ever happen again. I mean, there might be something like that. Information is key here. Getting the right information, getting it organized, documenting it to get it appropriately shared. In some cases, trade-offs, you might say. Our plan going forward is we're going to have to do some things differently. We know that now, either because we've been told or because we figured it out on our own. And there's going to have to be some trade-offs and getting involved with other parts of the organization about those trade-offs in terms of procedures or changes of materials or changes in some cases of suppliers or vendors, just because of some of the behavior that they have demonstrated is not appropriate for the reputation of the organization. And then the old appropriate, and then on trade-offs, who can make the trade-offs? Who has the authority and accountability to be able to make those kinds of trade-offs? Sometimes it's not you, and so you have to be able to be an advisor, but not necessarily the person that makes the final decision. Lastly, here, appropriate formality. You know, the whole record-keeping aspect of what records need to be kept, in what format, where do they get kept, and need to know. And these two things have been around from a legal perspective for decades. I mean, if you go into any, even today, 99% of the lawyers' offices have got these just giant paper file systems. Now they're getting better and better at scanning them, but they seem to also keep the paper as well, just in case the computer doesn't work. And so there's record keeping and need to know. Now, in today's world, you throw in the whole ability for instantaneous, unplanned, unknown documentation with social media tools and techniques, where all of a sudden someone's got a camera and taking a picture of something that you didn't know that they had a picture of, or shouldn't be, or they've got a camera in an area where cameras are not allowed, or they're sharing stuff over Twitter or over Facebook or whatnot that is supposed to be company private. Big issue, and facilities may not have as many intersections with those kinds of potential problems, but we could have some. And so telling your teams about the proper use and proper policy for social media tools and techniques, and checking your camera at the door or what have you, that's getting to be very, very challenging. And the lawyers are going crazy, I think, these days, trying to separate out, the documentation aspects of a particular case, and who has all of the information. You think you've got it all, but you don't, and then it shows up later at a time that was not helpful. Talked about some of the planning things you can do in terms of planning to help minimize or mitigate material safety data sheet documentation, things like that. Certainly is important. Risk, health hazards, safety hazards, exposure hazards, having that information available for people, training people to know where those policies, where those documents are, so you can say we're trying to prevent accidents from happening is our most important effort, and then of course dealing with them should they happen. But if we can prevent one, that's a lot more comforting than dealing with hurt individuals or broken processes or destroyed equipment. Putting in robust environmental health and safety policies in place. In many cases, those are driven by regulatory, local and national, regional regulations, but a lot of companies have their own environmental health and safety policies. HP had a ton of them, and we said that we do what the law requires, and we do this. And we think that and do this stuff just makes it even less likely that we're going to have some kind of an issue that's going to result in a exposure or a burn or a human factors complaint of some kind. Indoor air quality, indoor environmental quality programs in place are another area where facility management teams can do a good job of mitigating after the fact, or certainly help prevent problems from happening in the first place. So they kind of tie in with the whole EHS thing. Working with R&D and marketing, looking for the exposures. When you're told there's going to be some new outfitting in building number 3, second floor, west end, what's going in there? What kind of hexatrijuncide manufacturing is going in there? What kind of ventilation and drainage requirements, environmental requirements, access requirements? Are there some things there that we need to look at in terms of exiting and exposure and whatnot, and try to mitigate as best you can, so you don't have a problem that can turn into a legal quagmire just because you basically had mixed occupancies. We put the R&D guys in where we had an empty space, and that was maybe not the best place to physically locate them. And of course, as we said before, managing suppliers. We have many suppliers that do a lot of the work that has our name and therefore our company's name on it. And so taking everything we've talked about and looking at the contracts we sign and the service level agreements, that we have language in there, and we have testing, and we have validation, and we have reporting from the suppliers that they are in compliance with the same expectations that we set for ourselves, that we have to have them comply with as well, and then the auditing to make sure it really is happening. So very important that we do that. I mean, there's lots of examples where planning, if it's done right, makes a difference. If it's not done right, can be certainly a big problem. And the whole British Petroleum Gulf oil spill is going to be written about and used as a case study for decades, if not forever, in terms of coulda, woulda, shoulda, and what could we have done to prevent some of that stuff, and what were some of the motivations, and what were some of the beliefs and the drivers about business drivers versus health and safety drivers versus facility protections and whatnot. So it shows up in lots of different ways. What are we going to change? We're going to try to learn from a course like this, a webinar, to say, gee, what are some of the things that we might be able to do back in our shop, and see if there's any places we can tune up or take another look at what's going on. And my first advice whenever you're talking about making changes is assume nothing. Assume that you need to validate and verify everything that's happening right off the bat, and that risk analysis, that assessment process is key, because that's often where if you miss something there, it can end up causing you a problem further downstream, and you say, gee, I wish we would have thought of that back in June. We were working on that, and we didn't really close that loop. And so here's something that we could have maybe paid a little more attention, drawn the circle a little wider, involved our suppliers. We might have actually been able to realize this was a problem and mitigated it better. So what is the assessment? Prioritize the issues where the risks exposure are. This is not unlike a business continuity exercise. What are the risks that we're going to have if you're sitting in the Bay Area in California and you don't have a seismic safety program? That's pretty risky, if you ask me. Or if you're in Kansas City and you have no need for tornado shelters because, gosh, the chances of me getting hit by a tornado are only 1 in 1,000. Okay, well, that's good. Just make sure you stay on the 999 side, because it's a big problem if you don't prepare properly. So do your risk analysis, and starting with the big picture, and fill it in. What are the biggest things that can happen? Not some obtuse thing. What if some wild orangutan gets loose in the zoo and ends up in the HR office? That is probably not the kind of issue you need to be focusing on. And filling it in from the big picture, where the risks are going to be from the facility management. We have infrastructure. We have exposures to chemicals. We have exposures to equipment, electricity, high voltage. We have life safety systems that need to have power, UPS and whatnot. So there's some big places where we could have a failure of some kind on our watch that can cause a big physical problem, which could end up causing a big legal problem for the organization. And so we want to be able to kind of document that stuff and get it in place, and talk with other functions about those potential problems. Mitigation, being able to react, to be thinking about that, and having a mitigation plan in place. The what-if plan. Since you know that there are some of these things that have high risk, what is your response plan, and testing those response plans. And in many cases, testing those response plans from a legal standpoint, someone will ask, well, did you coordinate with the fire department, with the hazardous materials department, with the public works department? with police and fire safety. Well, gee, we thought someone could call 911 and everything would be just fine. No, that's not going to cut it. So having a good series of mitigation plans in place where you talk about this stuff, it's not write it down once and put it up on the bookshelf with all the other dusty binders, health and safety policies and whatnot, and first aid training. No, this has got to be something that's looked at relatively frequently, and especially from a facility management standpoint. As you see new processes, new changes in the company's strategy or products or mergers and acquisitions, those triggering events can lead to both physical facilities, real estate projects and challenges and problems, and can show up as legal issues as well in terms of now we've got conflicting regulations or we've got conflicting company policies. Which policy are we going to operate on? Or now we're working in multiple states, and this state doesn't have a policy on that, and that state does. And we're working in both sides of the country. We have to be prepared to deal with those kinds of issues. Lawyers deal with that stuff all the time, so it's not unusual for them to see multiple expressions of policies depending on the physical geography that your organizations are operating in. And then, of course, be proactive. Don't wait. That's kind of the summary of the whole change thing is be aware. Don't just sit back and say, we finally got this thing put in place. That policy's, been with us through and through since 1936, and by God, it'll still keep going. Don't be proactive. Don't wait. Be proactive. I think it's very, very critical. What are some of the best practices you might think about in terms of, from an FM standpoint? Meet regularly with your assigned legal representatives. Now, in some cases, those are going to be an internal person if you're a large enough organization, and depending on the complexities and the natures of the business product lines you have. In other cases, they may not be. They may be outside resources, and you should ask your manager, your chief operating officer, your CEO, your CFO, who is my assigned legal representative when I have a legal issue and there's a potential legal problem here in terms of labor or in terms of contractors or supplier issues. Who do I call? And not have someone say, well, gee, I hadn't really thought about that. Nobody's assigned to the facilities team. Find out who is assigned. You don't have to meet with them all the time, but it'd be nice to know who that person is. Document what your procedures are. Keep good records. Make sure people know what those records are. In many cases, the assigned legal representative is going to want a copy of all your procedures and records to make sure that they are aware, and they can jump right on the ball as soon as something happens. They don't have to say, well, gee, Kit's in vacation. We don't know where he kept the file on the chemical spill stuff or whatever. I mean, whatever it might be. So working with your representatives and documenting and keeping that stuff organized. Setting up legal performance standards for your suppliers, and that's where procurement, if you have procurement working with them, what are the legal performance requirements, and document those and get those into those contracts. And certainly with labor law is important. A lot of times facility managers say, well, I'm just getting the low bid. Of course, you're not realizing you're getting the low bid from a bunch of underage, illegal workers. So yeah, no wonder the price is great, because it's inappropriate, unfair, not right, illegal. So get those legal performance standards with suppliers clear, work out with procurement, and then check every time there's a contract renewal, discuss those things and say, how do we validate? Ask your procurement folks, ask your legal representatives, how can I validate that this is really happening properly? And then monitoring results and taking action quickly. Certainly there's, you can't solve a problem until you know it's a problem, and that's where having not just you, but having people on your team looking out for these kinds of things from time to time, and being able to bring help on board as needed, whether that's internal resources, external resources, in some cases networking. You might find that this is a problem. It's not an enormous problem, but it's a pain, or it's the SUD factors say it's not growing, but it could end up being something serious here. And talking within your FM network to say, has anybody seen anything like this before, and can you help me with some contacts, whether they're construction resources or human resources, environmental resources. Really important to get those people on board and document them and have a list of folks. Have more than just yourself be the person who can contact and tap into external and internal resources. So you might have a second or third in command who can also contact the legal folks and mount a response campaign if need be in your absence. Having a legal dashboard, what are some of the legal things that we need to be paying attention to? We just went through that. You kind of put together your own dashboard and say, what is it that I need to be paying attention to, on what basis, what do I do monthly, yearly, what have you, what are the triggers, standards and policies, what are those policies and standards, and getting changes. The lawyers get communicated with all the time about how things change, and they're talking and they're reading about cases and case law and judgments and whatnot, saying, gosh, look what happened to GE. We better pay attention here at Hewlett-Packard because that could come our way. Let's go talk to the GE folks and see if they'll be willing to share anything with us to help us from falling into that hole. Talked about documentation, talked about assessments and reviews. Don't assume that you've fixed it once, it's going to be fixed forever. Review progress. Every incident needs to have a review, a summary review to say, what have we learned from this, what needs to change. It doesn't have to be a month long, it can be an hour-long meeting, but it could come to a couple of ahas. I think we need to change some things here. Training and communication is important. Telling your team members in FM that there are legal issues that they need to pay attention to and that they can contribute to minimizing, then that gets them part of the team and makes them feel like they're being proactive and trying to be a problem solver. That's exactly the attitude you want them to have. And of course, getting good legal representation. If you don't have it now, ask someone, and even showing copies of the slide deck that I've shown you all today to say, these are some of the things that I was thinking about, we talked about today on a webinar. Love to make sure that I could talk with someone who's legally going to represent us should and if anything happen on my watch as the facility manager. So Clint's almost out of voice. Thank you for listening today. Hopefully I've provoked some thoughts in your own mind about the way you operate, the way you could operate, maybe have you reflect on some experiences you've had in the past that didn't go as well as you liked or went well, and you did a good job, and you're saying this is reason for me to reinforce what I'm doing and to share the best practices with other people, either on my team or outside my team. I'd love to certainly be a resource for anybody as well. Again, I'm not a lawyer. Don't call me for legal advice. But I'm a real believer in us talking with other fellow facility managers to try to help resolve problems and make our lives as successful and therefore as enjoyable as possible. So it's been my pleasure speaking with you today, and I hope you all have a great rest of the week.
Great. Thank you, Kit. If anybody has any questions, certainly please type them into the chat box. I do have one here, Kit. It's how do you get management to understand the environmental health and safety is a big part of risk and why we should have that?
Well, there's two ways. Off the top of my head, quick answer, there's two ways. One is experientially. See that big smoking fire pit out there in the back courtyard, boss? Well, that's a chemical disposal problem we had because we didn't have the acids and the oxidizers properly separated, and so we've got a big problem out there. It's a big fuel oil spill and whatnot, and so it's a big deal. We've not been paying attention. We've not been funding this. We put in requests for doing things. I mean, that's kind of the penalty, shove it in their face kind of a thing. You hate to have that happen, but there might be incidences that are not so serious that you can make a report on and say, these are the kinds of things that we're trying to prevent and mitigate, and we need to have resources, not, give me money, but say, I would like to have a particular budget for confined space entry, for hazardous material spill, control, prevention measures, and over the next 3 or 4 years, we're going to put in these following systems to help minimize, mitigate, or reduce, or eliminate the action. So there's that part. The second thing is most of the health and safety and environmental aspects of facility management are highly regulated, and there are consequences. And so getting help in your own organization to say, okay, who in this company, what person, name the person who, if whispered in the CEO's ear, this is a problem, they would pay attention to that person. And who is that person? And so go talk to them and say, hey, these are some of the issues that we're seeing that we're really concerned about, and we're trying to put in place a plan to mitigate and minimize the chance that we're going to have loss of life, loss of facility, loss of uptime. And these are some of the areas of our operations that we'd like to first study in a prioritizing order. I've talked to manufacturing and R&D, and they agree that this is where some of our highest exposures are likely going to be, and we'd like to bring in an outside consultant to do an assessment and to give us a game plan about how we might put in place facilities and procedures to minimize and to reduce our exposure. And that's basically using outside experts versus finger in the dike.
Great, thank you. I have another question. How often are facility managers included in errors and omissions coverage, typically extended to senior executive positions?
That's a tricky one. Depends on what is the activity involved at a facility. Typically, errors and omissions is by a private contractor or a consultant or an architect or an engineer. It's not an employee. Employees are in an incorporated company are protected by the company as an active incorporation. So employees, as a facility manager, you're not going to be sued for making an error and have to have coverage of an errors and omissions insurance. You can be sued because, you can't be sued. Your company can be sued. So Hewlett-Packard can be sued because of a problem that Kit Tuvison screwed up something and managed to start a fire, but the suit doesn't go to me. The protection I get is through the company. And so most facility managers will find, when they ask that question of their legal representatives, they are not individually liable. The company is liable, and they are protected under that liability policy. Now, that doesn't mean someone can't say, you've done something really, really stupid, or you went off on your own, and we perceive you did this when you were not working as an employee of the company. Well, then that could be a little trickier. But generally, that's errors and omissions is referred to liability by third parties.
Great, thank you. I have a situation that is not a large magnitude, but want to run it past you anyways. We lease part of the facility, but not the parking lot. We are going to a smoke-free campus, and I have been asked by the associates how it can be enforced if we do not own the parking lot. And are they also being told they cannot smoke in their cars? Oh, sorry, and they are also being told they can't smoke in their cars.
Well, there's official laws of the land, and then there's the official laws of the company. So in many cases, jurisdictions around the world have put in various kinds of non-smoking secondary smoke policies that talk about very specific separations of distances between smokers and non-smokers. And so where those things are codified in local law, the facilities team has to then implement and show, either with signage or marking, these are areas where you can or cannot smoke. If the company says, in addition to that, we're telling our employees, you're an employee, you need to be going farther away or what have you, then that's their right and privilege to do that, and that's a condition of employment. If you want to work there and smoke there, you got to be 50 feet away instead of 25 feet away, for example. The issue of a company saying you can't go sit in your parking lot and in your car in your parking lot gets to be problematic, and I'm sure there's probably already cases where individual rights have been questioned about. You can't tell me what I can or can't do in my own property. And I'm not a lawyer, so luckily I can say whatever I want. It doesn't going to be held up in front of a court. But I would think that's going to be a matter of an employee saying, how important is it, that I keep to myself and my own style, my own culture, that I allow myself to smoke. That may mean I have to go drive someplace else to smoke where I'm not physically testing those boundary conditions right off the bat, you know, kind of like in your face, so to speak. So, and if you don't own the parking lot, I think the company can still say the intent is we have an interest in not affecting our non-smoking employees. So that's the intent, that's the spirit, and we want you to comply with the spirit as well as the letter of the law. And people, this is where an HR person would have to have a conversation saying, okay, little Joe, you seem to be, in our view, trying to play a game here about seeing how close you can get to our employees with your smoke, instead of saying, no, my job is to not cause a problem. So that's not going to, you know, make us feel good about you as a contributor to our company if you're constantly trying to find ways to you know, tweak the system. I mean, that's the kind of the personal advice you'd like to be able to give Johnny, to say, you know, quit trying to screw with us. You know, let's try to find a way to make this a win-win.
Great, thank you. We are actually just about out of time, and I don't see any other questions. I did not say at the beginning of the presentation, so I will let you all know now. Yes, I will be sending out a PDF copy of the PowerPoint along with a link to the recording of this webinar, so you can access it later or refer back to the PowerPoint. Kit, is there anything you wanted to add before we end it?
Nope, it's an important topic, I think, for facility managers. The legal responsibilities is not something that many of us run into very often, so it tends to be a rusty skill. And I think periodically kind of tuning up yourself and asking the questions. And my suggestion is the best way to do that is to find out from your management team. If you say, hey, I saw this presentation on kind of legal issues from a facility management perspective, who is my official legal representative? If I have an issue like this, who would I go to? Well, that's a great way to start the conversation, and a great place for you to find out what really is in place right now, because there may be more in place in your organization right now that exists. You just don't know who it is and how to deal with it, how to find it. So it's a great question to start inside your own organization.
Okay, great. I want to thank everyone for attending, and there will be, as we exit the webinar, a survey will come up for you to rate, to express what you thought about this webinar. We eagerly anticipate those results, so I encourage you to fill that out. Thank you, everyone. Have a great day. Thank you, Kit, for presenting.
You bet. Thanks, Josh.
You're welcome.
Bye.
Bye-bye.